Thank you, Representative Phillips and the committee. I know it's late in the afternoon, and I appreciate your time. My name is Shannon Loyd. I oppose the bill as written. I'm a San Antonio coverage lawyer, have been for over 12 years, and I actually worked on the defense side as well. I want to focus, as Dr. Bonin said this morning, I want to focus on the what this bill actually does. This bill seeks to give profit-seeking entities and people in this state immunity, and no other persons who are profit-seeking contractors or small business owners have immunity from liability in Texas. And so if you, and I'm telling you from my experience as a policyholder lawyer and as a defense attorney, if you give adjusters a free pass, it permits them to get away with writing favorable estimates and favorable reports for the insurance company. Now, that's because they compete for the insurance company's business. And to your point, Dr. Bonin, I know that you just said if they're not acting the right way and they're not adjusting the claim the right way, well, why would the carrier continue to use them? The fact of the matter is they do continue to use them. I see the same adjusters, the same bad actors over and over from the same insurance companies. They hire these same adjusters over and over. Adjusters whose testimony I have, deposition testimony, and I've gotten evidence of their bad acts. I'd like to give you a few examples. In one case, we had an adjuster tell my client, who asked for additional living expenses, to move out of his home with his 3 young girls and his wife because the doctor had told them that there was asbestos loose in their house. They had had a car run into their house. And so this adjuster refused to give them the additional living expenses. And then he told the insurance company, don't worry about these people. Mesothelioma doesn't develop for decades, so we won't have any problem. I have another client who was given permission by the adjuster to use a remediation company and gave the remediation company approval of their scope. And when they submitted their bill after remediation, the adjuster told the carrier not to pay it. He told the carrier he had not given them approval. And then now my client is being sued by that remediation company. I have another client who was given approval to rent a storage pod to move the contents out of his house in order to have work done in the house. That adjuster then went, and when the bill was submitted, told the carrier, I never gave them permission for that, don't pay it. We have other instances where adjusters have started working a claim and then have disappeared for months. I have a case right now, a condo in San Antonio, where the same adjuster from the same big multi-million-dollar national adjusting company was working the claim and then just went missing for months. So if the basis of these claims and these lawsuits against these adjusters is their wrongful underscoping of damages, or their helping the carrier, giving them a basis to deny coverage, then they will be incentivized to increase doing that because they'll have no immunity.
So what do you do to the person who just sent a check and clearly did nothing wrong, but they're just getting sued because of venue issue? How do you solve that problem?
Motion to dismiss.
Yeah, more cost, more times in federal court. Motion to dismiss.
Well, that's right. They have that avenue. And I don't know the adjusters that were speaking. I've never heard of them before. But here's something that no one has said. A lot of these adjusters are not employees of the insurance companies. They're independent adjusters, and they're on their own, and they're, again, profit-seeking entities. But I'll tell you this, Representative Phillips, in over 12 years of litigation, and since this new law has been passed, not once have I had any defense lawyer file a motion for summary judgment on their adjuster or a motion to dismiss, not once. And so if they are truly not a bad actor...
How many of those went to trial?
I have had 10 trials in 10 years.
Yeah, so how many cases would have been filed that you settled at mediation with those people still? I mean, why am I going to pay a defense lawyer to file a motion for summary judgment and something else if we're going to settle the claim? to avoid the cost of going to court?
Well, a motion to dismiss filed within the first 30 or 60 days of the lawsuit being filed is a very short motion. It's basically you don't have a basis in law or fact. I don't know what defense attorneys bill these days, but I can't imagine it's any more than a 2 or 3 page.
If you think in Texas that those little provisions are widely used, maybe they are in your jurisdiction, but people don't follow those. They don't take them lightly because they know the judges don't like them to be bringing stuff like that against lawyers that regularly appear before them. I mean, it's not easy. I'm sorry, you just don't have a lot of those happen.
Well, I've never had one happen, but
I know,
if you have that
and
avenue.
Just because you have it doesn't mean you exercise it. I just think, just from my experience as a lawyer, I haven't been a lawyer forever, but long enough to have gray hair now from it. I just don't see people bringing those kind of things in a lot of cases.
Well,
in all kinds of matters, it's just something that lawyers tend not to do.
Well, I tell you, the adjuster that spoke earlier who said that he had done his inspection and everything and they had already sued him, that would be a great motion to dismiss. That would be that should get dismissed. And so if our judiciary is doing their job, then that would work. The last thing I'd say is something that no one else has talked about today. And I do appreciate, Dr. Bonin, what your purpose is with this bill. As a lawyer who is a boutique firm, I have 25 to 30 cases at any given time. I don't advertise. I appreciate what you're trying to do with this bill. The 60-day notice provision, one thing I think that might be problematic about it is that half the time my notice letters are ignored. I don't get any response at all from the carrier. And so what I'm afraid of is what happens if they, on the 59th day, say, okay, we want to inspect. So does that mean the policyholder has to wait longer and wait for that whole inspection process to play out? So that's a concern I have about just the way the wording of the bill is. And so I'm happy to answer any questions. I know y'all are tired, but...
Just a quick question.
Yes.
From the San Antonio area, I guess, have you seen an increase in lawsuits from the last year?
I have not. I've seen the billboards and all the things that we've heard people talk about. I actually been down at the courthouse a couple of times. Our district judges came up with some standing orders, like down in Hidalgo, for pretrial discovery. And they did it because they were readying for the onslaught of litigation, and they just haven't seen it happen. In fact, now they're letting people opt out of the standing order because they just don't have the mass litigation that they were expecting.
I'd like to ask you a couple of questions, a little off topic of your testimony, but because you obviously know the process really well.
Yes.
So my house was one of the ones in McKinney that was held on pretty significantly just the other day, my house and my car. A new car for me anyway. As a matter of fact, if the Titleist aerodynamic people know what they're talking about, I should get a lot better gas mileage going forward because of all the dimples in my car. But so now that I have hail damage, do I have an obligation to contact my insurance company? Or could I just go to my next door neighbor who might be an attorney in this area and say, hey, can you give me, can we just go ahead and sue?
Well, your policy requires that you give notice of loss to your carrier. And so what that means is if you know it's hail damage, obviously you can see all the dents in your car, then you'd say, hey, I have hail damage. If you have your roof leaking but you don't know why, then your obligation is to say, insurance company, I have water coming in but I don't know why. That's giving notice of a loss. And you have that duty.
The answer, you could file a lawsuit and that'd be noticed.
So a lawsuit could be noticed. So I could run straight to the lawsuit phase.
Well, that wouldn't be the way that it should be done, and that certainly wouldn't be the way that I would do it. But your duty under the policy is to give notice of loss.
Okay. Thank you very much.
Just a follow up to that. So if I were your client and I had the situation that Mr. Sanford just described, your advice to me would be, we're not filing a lawsuit. You need to file a notice with your insurance company.
Absolutely.
That you sustain a loss.
I would say, have you made a claim yet? What was the claim decision? If you hadn't even made a claim yet, then I would tell you, I can't help you. You don't have a dispute with your carrier yet because you haven't even given them notice of loss.
Okay. And would would you think, fairly typical legal advice that lawyers in this field would provide to clients that you follow those channels?
Well, look, there's no doubt there's some bad actors out there. As I said earlier, there's bad actors in everything. A good policyholder lawyer would tell their client that.
Thank
A
you.
good, responsible one. Thank you all.
Thanks for staying and coming up and testifying.